Welcome back, everyone. Jerry Pitts is with us today. I joke with you, we're going in the Wayback Machine because there's a couple of colleges, actually groups from those colleges, that I brought an issue before the Supreme Court that they're now hearing about affirmative actions in the admissions process at these colleges. But to understand it better, you mentioned that we have to go back to the original version, what the idea was behind affirmative action.
Exactly.
Right? Yeah.
And that's the reason we have to go back, because we want to understand how we got to where we are. But actually, in short terms, since the legislation went into effect, it started with Kennedy. Kennedy just couldn't get it all done due to his untimely death.
Yeah.
Johnson got in, and due to Dr. Martin Luther King's urging, he carried on the ball. Then President Nixon took over the last component of the affirmative action by saying that employers could consider sex and race as a criteria for employment. So those were like the three categories.
Sure.
But since then, states as well as the Supreme Court has been quietly chipping away at it. In fact, the only thing that is left in that affirmative action plan is dealing with colleges and universities.
Right.
State and private, and what they can or cannot do. Now, we have to recall that earlier in life, they used race as a criteria to include you. Now they're saying you can't do that. A lot of it doesn't make any sense. For example, let me give you an example, and we're going to get to these other things.
Sure.
In Harvard, the policy is if your parents went to Harvard, your grandparents or whatever, it's called legacy.
Sure.
If they went to Harvard, then you had a leg up. That gave you extra points.
And part of the reason being that the chances were that your parents were going to donate a lot of money to the college, too.
And the fact that your parents, how likely was minorities going to be in that group that got in Harvard a long time ago?
Keep the same cycle of people going through.
They were systematically excluded. So seats are already open for those who they call legacies. So they're not even approaching that. Harvard and the University of Kentucky, that group that you mentioned earlier, their reasoning is reverse discrimination is against white people.
Yeah.
It really makes very little sense. Now, I'm going to tell you about one case that came up with the state of Michigan on this affirmative action. The question was dealt with the University of Michigan. In the year, I think, 2013, they said you cannot use race as a plus for undergraduate, but you can for graduate and above, okay. Doctors, lawyers, etc. So they gave a decision that actually contradicted itself.
Yeah.
They turned around the Supreme Court in 2014 and then said, ban it altogether. They said that the state of Michigan, who had put it on a referendum to ban all affirmative action, and the state of Michigan approved it. Surprisingly, the Supreme Court then said Michigan had a right to make that decision against the Constitution.
What's fascinating is, and a legal scholar brought this up the other day, is that the argument that both sides are using the same argument. You shouldn't be able to use race. Back in the civil rights movement, it was to reverse years of discrimination against minorities. Now it's white, college applicants and Asian college applicants saying, you're using race, you can't do that against us. So it's so weird they use the same argument, isn't it?
So it's just, what they're doing is just shifting the ground.
Yeah.
Shifting it. But it doesn't change anything. We're right back as we were 70 years ago.
Square one.
And we're arguing about the same things. Now, what really puzzles me, our Supreme Court Justice Clarence Thomas, he got into Princeton and Yale through affirmative action.
Yeah.
However, he's voting against it consistently every time.
Yeah, we'll see what happens. All right, we'll do a part 2 on this one. Thank you, Jerry.
Yes, indeed.
Good seeing you. Now, going medical news coming up next on Noon Edition.